nuanom Ghana fo sisi amene mo ka say de e Richard Jakpa e de no kran no ababeto abonten say eye ndi siamanyuku na anase AsieduNketia ene tua ne sika anase AsieduNketia na ebo ne pa so onko no kotwa ntronto eye Attorney General Odame so we ni nsem a ekoso wo ndi siamanyuku no afenso Richard Jakpa hu say nsem bi a ekeka kono eye buabo no efise asem no hwemu kra ase on shede ni mu hwefe so no the third accused but as he said nsem ni na edane ekone so a eye asem ketua a oje no ho a onje te sia de esiam ne mo ka se de odi no kra no ababetu abontin aka nipa ko a oye responsible na se nipa ko tua ne se onko twantro etu Attorney General Odame so ti assembly na kunu kuti sa ensem otwa mu bra madam ase
ades na wo chirim se ukohwesa case no a na ye wo breaches to a privacy right na emom no court no egina emra ahodo so edg an audio recording to mu a ene case a ekoso e wo the Accra High Court eno no eye pepepe. Now let's look at the admission. Was a Justice Asaribotwe per her ruling admitted the audio recording subject to wait to be placed on sale by the court. Her ladyship heard that the conversation on the tape has not been denied by the Attorney General and that there was the need for reciprocity as the Attorney General would have had its evidence admitted if same was procured by breaches to privacy rights. Her ladyship in her ruling drummed on the provisions of the Electronic Transactions Act 2008 Act 772 and the permission it allows for the admission of electronic evidence subject to some exceptions. Enti ahano na Justice Efia Sewa Saribotwe her ladyship enchiremu ana wode mane se de edikan ene no ayete no wasa audio recording no the Attorney General Godfrey Odame Emma Bonten emeka se enya nene enti ahono nchichiremu wo ho na sa na tie nso a sa evidence sa Attorney General ne ekura no ena nka wode ba as evidence nka it will be admitted said the beya nipa no a one ne mienu ne ewo tape no so no ebetu bi di nchichiremu aba with regards to nkomodi a ekọ so tape ni enti no if it is against the Attorney General na ontumi me deny say conversation no enye wono ade a then e wose ye ba kwan ema nipa mienu no obi a ebo no nkuro ena her ladyship esan echiremu say okenkan Electronic Transactions Act 2008 Act 772 ema kwan for admission of electronic evidence subject to some exceptions. This exception be any one there. The Electronic Transactions Act 2008 Act 772 ema kwan se court ebeji electronic evidence ede atumu ede ayedwuma ewo court. Now caution. Her ladyship took the opportunity to caution against ambush litigation and waste of time of the court. Enti odi ruling nyina to abonti wiye no ena osan ede saa kwanya to hono se manso twen ye hu hia ya ebese court no adaje o case hu de enya de a ono Justice Efia Sewa Asaribotwe obeso so kra there be onso so de biarada. Enti immediately ya her ladyship kasa wiye no ena cross examination by lawyers of the third accused Dr. Kesilato Forcing on Richard Japkah on the admitted tape no eshasi. Now, ladyship Justice Efia Sewa Saribotwe can say answer na cross examination no eshasi. Our question be our per se Richard Japkah through the lawyers of Kesilato Forcing or more cross examination be address. One, there is a commentary out there say a Justice Yoni Kulendi Supreme Court Justice and a year arrangement for that said meeting in his house with the Attorney General without the notice of the Attorney General say Richard Japkah will be present at the meeting. And na ebinum so nam say Attorney General no request that meeting from Richard Japkah because say na our proud motive be say yeah it was so jelly the minority leader case lot of force enti saying Nketia Enunti Emma lawyers for Dr. Casey Ato Forsen. The first cross-examination question Umbusa Richard Japkah said, who requested to have meetings with the learned Attorney General? And Richard Japkah say, and okura pan wasem say, eye ono Richard Japkah and requested to have meetings with the learned Attorney General. And na question say, how many times and ono Richard Japkah requested for meetings with the learned Attorney General? To pay Mr. Richard Japkah, or say he met the learned Attorney General 4 times. 4 times. And I was saying, the AG obliged him his request. Till a very interesting cross-examination, of course. Richard Japkah did to say, after or no mum ne request say, or person one Attorney General. But in all the requests, the Attorney General obliged to all of the requests. And now, Ono Richard Japkah, passing through Justice Kulendi. Passing through Justice Kulendi, no. And because of Justice Kulendi, the Attorney General agreed a meeting with him through Justice Kulendi. And this means that the Attorney General only agreed to meet Richard Japkah because of the learned Justice Yoni Kulendi. Tinkomo eko soma Justice Yoni Kulendi to me convince the Attorney General to meet Richard Japkah through cross-examination in Yanabipi. And Richard Japkah said, the purpose of the meeting was to allow him explain the whole story and why charges against him were unfounded. And from the narration Richard Japkah was giving in court today, everything was about him. Yemo to force in diwa. To arrange that particular meeting to let the Attorney General know the entire story and that charges brought up against him, Richard Japkah, as the third accused person, was unfounded. Throughout the discussion, the first accused had to force in Yemo Nidiwa. And Richard Japkah said, upon the meeting, he had enough time to explain his story. Now, during the course of the cross-examination, he also made a narration of a conversation between himself and the learned Attorney General in the presence of the learned Supreme Court Judge, Justice Johnny Kulendi. In response to a question from the learned Dr. Bassett Bamba, the accused Richard Japkah said he holds the view that the prosecution was based on witch hunting and political points scoring. He said, per his narration, the goal of the prosecution was also to have the seat of the minority leader and first accused declared